The question now is, how did we get here? And so this is a chart that I've been using for some time with slight modification, and it's one I'm quite proud of because the bubbles I drew all by myself. So what I've tried to do is understand what has been the stage of market development over time, and I break it into 3 generations. So the first generation for me really goes back to the 1980s when Congress created the Court of Appeals for the Federal Circuit. Everyone in this room is quite familiar that prior to that, intellectual property was not highly regarded, in part because its enforcement was not predictable. Well, the CAFC, or Congress, had a desired effect. It began to show that you could enforce your intellectual property rights, and that led to a resurgence of competitive litigation between IP owners. Well, once you knew you had a chance of enforcing your IP against your competitor, we entered into the late 1980s, the early 1990s, this period of defensive cross-licensing, where Company A would knock on Company B's door. They wouldn't end up in the courts, but they would end up sitting down and striking an agreement. In most cases, those were cross-licenses without any payments being exchanged, but into the early 90s, we began to see what we called expansion or royalty-based licensing. Either we'll trade, but it's not even, so you have to write me a check, or we'll go outside of our industry and we'll license our IP simply $4. And I remember for me this was significant coming back to Michigan with Ford Motor Company. So we created Ford Global Technologies in the early 90s, and I sat on that board as the only independent director for 5 years. And I remember when we would collect a few $1 million, or over the course of a year, $10 to $20 million, and that was a meaningful amount of royalty income. Obviously, things have changed dramatically since then. But overall, this first generation from the early 1980s to the 1990s of IP market development, we classify as a period of feudal lords. Just like the property owners of old, if you weren't a property owner, if you weren't a large patent holder, intellectual property was really not of interest to you. It wasn't something that was talked about at cocktail parties, and it wasn't something that was read about in the paper. But we can see that Congress had its desired results. So if you look at the number of patent case filings since the creation of the Court of Appeals for the Federal Circuit, the trend is clear. What's also interesting is now we begin to enter into the second generation in the early 1990s. And this second generation we refer to as the rise of the intermediaries. Because once it was understood that you could take intellectual property and you could go and license it for dollars without the necessity of a cross-license, then it became clear that you could actually separate the intellectual property from the core business and achieve substantially the same result. So the notion of taking IP and putting it into a separate holding company or spinning it off entirely, today an idea that's common, was innovative back in the early 1990s. And that led to a series of players coming into the market that we didn't really have before. The most basic one being contingent counsel. How many remember the day when the notion of your law firm taking on a patent case on contingency, that was only for the guys who couldn't get business any other way. No reputable firm was going to be in the contingent IP business. Today, that's obviously completely different. Most every large firm has a portfolio which includes some significant contingent patent litigation. But we also saw the development of web portals, starting with PLX, but eventually growing to more than 60 portals, 60 patent something or other.coms, trying to list intellectual property for sale. That led to a resurgence of patent pools. The first financial instruments were the Bowie bonds, where you could look at royalty income as a separate instrument. And then finally, for Tomo, the development of the public auction. First discrete auctions, and then ultimately the large public auctions with 50 to 100 different lots. And so what we saw in this rise of the intermediaries were, in fact, that the number of players and the players themselves were changing. So what's shown on this chart is the balance of litigation based upon who's the plaintiff, with those NPEs or PLEX shown in red and the traditional commercializing entities shown in blue. And clearly, by industry, you can tell there's a substantial distinction. The NPEs or PLEX began to target certain industries and not others. What also changed was the element or the computation of damages. I see in the room today some old friends, and we've been in the expert witness business together and separate for more than 20 years. And the business started, it was always a lost profits case. it was always company A sues company B, and they're talking about sales and profits, because if it wasn't about that, they probably would have settled long before it got to litigation. Today, in my practice, or my firm's practice, it is 80+% royalty only. That lost profits today is an unusual claim, relatively speaking. And that's a big transition that has occurred because of the changing players in the marketplace.